I'm happy to be here. All right. Let me go live on Instagram also. So hello and thank you, and it's a pleasure to be here with you today. And so thank you and welcome to welcome to another episode of Deportation Defense Live. All right, we're live. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. And you're here tuning in to another episode of Deportation Defense Live. The question I want to answer today is, can I return to the U.S. if the crime I committed was decriminalized, was vacated, was set aside, it's no longer a valid crime against you? Okay? And so that's the question I want to answer today. So thank you for tuning in. And as we go through that, if you have questions, please send them over. I've received a few already. And so we'll get into it. So first of all, welcome. Thanks for everybody for being here. Instagram, TikTok, Facebook, YouTube, LinkedIn. Thank you all so much for being here. Remember, the Deportation Defense Live is here to train, teach, inspire, and empower immigrants who are facing deportation to make the most out of immigration laws, to make the most out of their lives, and to win their cases. All right? Are you facing removal in immigration court, or do you know someone who's facing removal proceedings in immigration court? Because if so, you know that it is not easy. It is an uphill battle. The laws are against us. And here at the Deportation Defense Live, we're here to maximize your chances of winning that case. Got it? So today our theme is, can I return to the U.S. if I committed a crime, but then my crime was decriminalized, vacated, set aside, right? Legally invalid, all right? And so thank you for everyone who asked your questions. We have 30 minutes to discuss this topic in English, and then we'll get into it in Spanish, okay? So the basics, right? The basics. To be able to re-enter the U.S., we want to talk this through. So basics number one, certain criminal convictions make a person inadmissible or deportable under immigration law, but there's other conduct that can make a person inadmissible or deportable too. And so the first question is, if your crime was decriminalized or vacated or set aside or whatever, the first question is, does that actually benefit you for immigration purposes? All right? Like, you might have some other issue, right? You might have an unlawful presence bar. You might have what we call a permanent bar. You might have a fraud bar or a fraud inadmissibility, or maybe you've made a false claim to U.S. citizenship, right? Or maybe there's some other issue besides the crime that's causing you to not be eligible. Have you had unlawful presence in the United States? All right? And so the question is not just whether or not you have a conviction. The question is more like, is it only that conviction that's preventing you from being able to legally re-enter the U.S.? Does that make sense? That's like an important basic point. We got to be on the same side about it. We got to be clear about it. The second basic point, right? And this is very basic, so hopefully stay with me, all right? You can only lawfully re-enter the U.S. if you have a valid visa, a valid green card, some other type of travel document, maybe an advanced parole travel document. So, even if your crime was quote-unquote decriminalized or vacated or set aside, I'll use those three words, even if your crime is no longer a crime, or is no longer a quote-unquote conviction against you, if you don't have the travel document, right, you still won't be able to re-enter. And you might be able to get that travel document, or often it's a green card, you might be able to get it reinstated if it was, for example, taken away from you in error, right? But if you never had a visa or if you don't have a visa, you might need to reapply for one, which is not like automatic. It's not just easy, right? So, in other words, decriminalizing or vacating or setting aside a criminal conviction might not help you there. Okay, you got to be aware of that. So anyway, so those are the basics. But if you have both of those, right? If you have both of those, and your only issue is the conviction, right? And you have an approved or an approvable travel document, then if your conviction gets decriminalized, vacated, set aside on legal grounds, then yes, there is a way to having all of that in place to re-enter lawfully the United States. All right? Procedurally, these are not easy to do, and you're going to need help walking and navigating the process. But yes, it is possible. Okay? When you do that, and when you re-enter, you're going to need to have evidence very clearly delineated in, it's to be able to present yourself to customs. And if you previously had a deportation order, then you have to have an approved motion to reopen and an approved order allowing you, that you show to the border or to customs, to allow them to enter the U.S. Okay? So you will need help with a law firm to help you coordinate all of that. Okay? And so, what if there was a deportation caused by the crime? Well, first of all, let me back up a second. A lot of people, I have a lot of clients that end up getting deported, or they're consulting with us after they've gotten deported. Hey, what can we do? And many people believe that the deportation was because of their criminal conviction or because of some arrests that they have. But sometimes, if you review that record more carefully, sometimes people were actually deported just because they entered the U.S. unlawfully, or just because they overstayed the valid period of their stay in the U.S., right? Like, just because somebody also has a criminal record doesn't mean that the government needed to use that record to actually cause the deportation. All right? I hope that made sense. And if you were deported only due to the conviction, and if that conviction was now set aside, decriminalized, vacated on legal grounds, you should be allowed to apply for reentry. You've got to show that if it weren't for that conviction that now is no longer there, you should never have been deported in the first place. All right? And so it's basically like, look, if you undo the conviction on legal grounds, then yeah, you should be able to undo the consequences of that conviction on legal grounds also, including sometimes a deportation. Got it? All right. So, one detail that I've just got to say when I'm on this topic, and then I'll get into everybody's questions. It's important to note, right? If you're outside the U.S. and you're wanting to fix all of this, and you're going through a criminal process to vacate your crime, and you're filing motions to reopen to be able to re-enter the U.S., which is not easy to do if you're outside the U.S. It's normally impossible. The departure bar makes it impossible normally. When you're going through that whole thing will take time, all right? Often a few years. You cannot try to re-enter the U.S. unlawfully during that time. Otherwise, you will trigger a permanent bar and it will destroy your case. Okay, so that's something you need to be aware of. And a couple of other things, okay? A couple of other things that you got to know. There's some cases, all right? In 2022, actually, there were several of these cases. The BIA, various circuit courts where they're deciding that if there's post-conviction relief, if a crime gets vacated, set aside, but if it's set aside solely for immigration purposes, it doesn't work. All right, there's cases saying that no, it has to be set aside on legal grounds, on substantive or procedural legal grounds in the criminal case, and it can't just be for immigration purposes, right? The case I'm holding up is a Ninth Circuit case decided on August 15th of 2022. It's Ballinas Lucero, and you could take a look at that and the language in it, all right? And it talks about, if you undo a conviction for that to work, it's got to be on substantive, all right, or procedural grounds, like showing that there was a problem, a legal problem with the conviction from the beginning. You never should have been convicted at all right? And that's what you need to show. You can't just ask a criminal court judge to set that aside for immigration purposes. That does not work, so you got to be careful with that. But basically the rule is, yes, if you undo a conviction, you also are allowed to undo the consequences of that conviction, which sometimes can allow a person to re-enter the U.S. All right, so that's my main point today. Hope this was helpful. Hope it was useful. I want to get into some of your questions, and then I need to wrap up. All right, so a couple of questions. First of all, thanks. Everybody who's joined me here on Instagram, hello, I see you. Thank you for being here. Everybody on TikTok, YouTube, Facebook, LinkedIn, thank you all so much for being here. I really appreciate you all being here with me today. One question I had comes from Tilema, I think is, how do I say your name? Tilema, you say, I came to the U.S. Embassy here in Fiji to apply for a visitor's visa, but I was denied. The officer said that I could qualify, but, and then I don't see the rest. The question was sent incomplete. I'm sorry about that. Okay, so Tilema, send me the rest of your question when you can, but I am sorry to hear about it. Here's the deal with tourist visas, visitor visas. They are very up to the discretion of the officer, right? They're very difficult to control, right? My office applies for tourist visas. Other firms apply for tourist visas. Some get approved, some get denied, all right? Certain countries are much more willing to approve tourist visas. Other consular posts are like, it's very difficult in certain places to get a tourist visa approved. And it's just the reality, all right? It can be very, very frustrating. Often there's not a whole lot we can do about it. Unless you qualify for some other visa that might have a more solid legal basis, right? Like if you're married to a U.S. citizen, or if you've got some other legal ground to be able to apply for a visa, they take longer. Those more secure types of immigrant visas, or even a more secure type of non-immigrant visa, like a student visa, for example. But visitor visas are tenuous. They are easy for the government to deny, for the U.S. consular officers to deny them. Okay? Hope that was helpful. I'm sorry that you're in that situation. The next question I see here comes from Fabi. Fabi, thank you for asking your question. You say, hello, I'm a U.S. citizen. My father was deported 18 years ago. He has a criminal record that's 18 years old. Is he able to come back? Okay, Fabi, thank you for asking this question. The first step in all of these questions, the first step is let's do a thorough review of the record. Let's see really why he was deported. Was he really deported because of the criminal record, or was he actually deported because he had violated immigration law, okay, in some way? And so, let's get to the bottom of that. The way to start a case like that, Fabi, is give our office a call. We can do a consultation. We can understand the facts better, and hopefully we can request all of the records for your father so that we can get to the bottom of what's the best strategy for him. Okay? Good. And if you're a U.S. citizen, you have the right to file a petition for your father. But before you do that, let's get to the bottom of whether or not your father, in his situation, would be able to use that petition. Make sense? Okay. And sometimes you can, right? Often it's a 10-year bar, and he's already been out 18 years. So that, in theory, you might have a case. All right. I see a question here from CE User. CE User, thank you for asking your question. Your question is it possible to undo it even when a person has already departed the U.S., and can he come back? Yes, it is possible. It's not easy, but yes, it is possible. All right? Our office has done that. Our office has won that. It is possible. It's not easy. Okay? It takes a lot of work with criminal defense experts. It takes a lot of work in immigration court to undo the consequences of the crime, exactly as I've been presenting on today. CE User, what happens to the visa? The way it works is if it was only the crime that caused the deportation and the taking away of a green card, right? Then you can ask a judge to reinstate that green card and lawful permanent resident status. That's the way to do it. If your person has a visa, then they need to vacate the conviction and then reapply for a new visa. So that's not yes, they can come back, but they've got to do it through the consulate. Yes, so the answer to your next question, CE User, will the person need to reapply at their home consulate? Yes, that's right, okay? CE User, you say, thanks, asking my question on the fly so I won't forget while the discussion is fresh. You got it. Hey, thank you for asking it, right? Thank you for being here. My next question comes from Luis. Luis, thank you. You say, good afternoon. It's morning here. I don't know where you're watching, but cool. I filed my affirmative asylum case with U.S.CIS in October 2022. I got their receipt notice. However, it's now January 2023. I received a letter from DOJ scheduling my master calendar hearing. Cool. All right. So you're going to need an attorney, and we'd love to help you with this. And you might have an argument with jurisdiction. All right. I love the way that you've done this. You might have a clever argument that actually the asylum office should have jurisdiction over your asylum case first because you filed it with them before your case was in the jurisdiction of the immigration court. That may or may not work, all right? But it's something to talk through with your immigration attorney. Could you try to terminate proceedings in court arguing that the asylum office has jurisdiction over your asylum case, all right? Because you filed it affirmatively first. So your questions, Luis, is should I file my application now with the immigration court, or should I assume U.S.CIS will provide the court with my application files? Talk to a lawyer first, all right? If you could do a motion to terminate and fight your case in front of U.S.CIS, that's 1,000,000 times better for you in a lot of ways, okay? Talk to a lawyer first. I'm not going to answer that question live. Talk to a lawyer who is going to represent you through this process. I promise you that'll be better. And make sure that lawyer's freaking good and knows what they're doing, all right? And if you want my office to help you with that, hey, give us a call. I'd love to. I love cases in your situation. All right, your next question, though, is could I request the immigration court to consider my application retroactively so that the clock is not reset? Ooh, I like this question, too. This is a good question, too. Can I apply for EAD 150 days after October 2022? I mean, the regulations say, hey, you've got an application that's been pending since that time. And so, yes, all right, yes. Now, the problem that immigration will have with that is if the court administrator's clock doesn't show 150 days, right, then you might need to let the court administrator know that you filed it ahead of time, and you might need to send them proof of the filing date and the receipt notices and all of that stuff. But sometimes when you apply for your EAD, if you just show that filing, I mean, I think you're eligible for an EAD. I think you should submit it after 150 days. But the proper way to do it is to figure out what you're going to do in court first. Like, could you do that motion to terminate like I discussed, or could you apply to ask the court administrator to turn the clock back to the date of your initial receipt? Okay? All right. So thanks, everybody. I am over time. I've got to start this in Spanish, or I'm going to be behind for the rest of my day here. So let me wrap up. Thanks to everybody who asked their questions. CE user, thank you. I really appreciate it. Luis, thank you for asking your questions. I appreciate it. Fabi, Tilema, thanks to all of you. Everybody here on Instagram, By the Bay, California, Paz, Holistica, Naranjo, Senor, Ivo, Jarjeto, sorry if I'm mispronouncing the names. Hello, thanks to each of you on Instagram, everybody on TikTok, Facebook, YouTube, LinkedIn. Hey, welcome, and thank you so much for being here. I really appreciate it. And so, Luis, you're welcome. Thank you. So, and hey, I love your case. Please reach out if we can help you with it. I'd love to have my office help you with that, okay? So have a great day, everybody. See you, user. Have a great day, too. I see you there. So that's all the time. Hey, if you still have a question and you're tuning in, please send me your question. I'll upload it to YouTube. The best way to see that, please subscribe to our YouTube channel. Please hit that notifications bell, and you'll be notified when we update additional updates, news, things like that. And lastly, of course, if you have an immigration case, hey, please give us a call. We are here to help. We would love to help. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. I hope to see you next week on our next episode of Deportation Defense Live. We also have a live show called The Empowered Immigrant Live on Thursdays at 10 a.m. Pacific. And so join us for that as well. Thanks, everybody, so much. Hope you're doing well.